Probability of paternity of both of these is 0%. So the court so finds that Mr. Black is not the biological father of the children at this time. This is in the interest of Gittens' minor children. We're dealing with two twin little girls. Both of them look like they're going to be, what, 2 years old this year. Anyway, the non-custodial party is Taniel Black. The custodial party is Kristen Gittens, and this matters before the court on petition established parent-child relationship. Let's see, there was a first amended petition filed, and we've been operating under a temporary order since, looks like April of this year. Court will note the court did substitute Ms. Swartz in for Ms. Garcia in this matter as the ad litem. Anyway, I'll ask the state for an opening, let's see what the state's requesting we do here today and what kind of agreements and contests we have at this time. Thank you.
Thank you, Your Honor. So I have reached out to Ms. Swartz, and she communicated, or her paralegal communicated to me that they had no objection to proceeding without her. The reason for that is because we have negative DNA results. So would ask the court to do an order, and neither party, I believe, is going to dispute the negative DNA. So would ask the court to do an order adjudicating that Mr. Taniel Black is not the father, and then we would need to get some language voiding out the obligation was created under the temporary order. So I'd seek the court's guidance on how the court would like that order to read.
This was not an AOP matter, correct?
No, sir, Your Honor. This is a paternity action.
All right, then, folks. I've got in my hand right now Stakes Exhibit number 1. This is the DNA test for both the twin little girls. Is there any reason I should not let Stakes 1 in at this time, Mr. Black or Ms. Gittens?
No, sir.
No.
All right, so Stakes 1 is admitted. Stakes 1 shows that Mr. Taniel Black as not the biological father of the child, Nikayla. I think that may be how you pronounce it. And is not the biological child of the child, Melissa. Probability of paternity of both of these is 0%. So the court so finds that Mr. Black is not the biological father of the children at this time. Let's see. I'll go ahead and order the prior order null and void. We're gonna do away with it. Let's see what the original order said. How did we get there? Did a job without a DNA test and AOP? Okay. The court did appoint Mr. Glass as the ad litem for Mr. Black, SCRA attorney. And that original order did appoint Ms. Garcia. The party's married?
I don't believe so, Your Honor.
Okay, just want to make sure. Okay, it was a default hearing. Did not file an answer. The court did appoint it ad litem. Okay, and did a temporary order. All right. So, what's the state asking for us to do here today, and what's the ad litem asking for us to do in behalf of his client? Thank you.
Well, Your Honor, so I'm requesting an order that adjudicates Mr. Black as not the father, and I'm seeking some guidance from the court as to how that order ought to read that voids out the temporary order.
At this time, the court finds that obviously he's not the parent in this the child in this matter. Court this time is you can non-suit it, we can dismiss it, we can do whatever is necessary, and there's no obligation going forward on this matter.
So my preference, Your Honor, is if I can draft an order that specifically makes a finding that Mr. Black is not the father.
Well, that's part one for sure. Yes.
Okay. So my preference, Your Honor, would be to include also in that non-adjudication order some kind of language that voids out the temporary order. But I guess I'm just seeking some guidance as to the form.
Well, again, Mr. Diamond, that's not my. I didn't do this for a living, and I figured the state has done more of these orders than I ever have. But the bottom line is, whatever the state wants to do as far as that order is concerned, I'll review it and see it. But again, we don't have a template for that, sir.
I understand, Your Honor.
So, is there anything that Mr. Glass is asking to be in the order, please?
Just that I'm released, Your Honor.
All right, that'll be part of the order. And again, the order of non-parentage and And if there's any unpaid child support in this matter, the court will forgive that, obviously. But anything that was done prior to that, then I can't undo because it was part of the court order and it was a legitimate default hearing. So, anything else, Mr. Diamond?
No, that's it, Your Honor.
All right. So if there's anything, oh yeah, I said everything is suspended. Child support, any type of access, visitation, that's all gone bye, and anything that's owed is dismissed. All right.
Yes, Your Honor.
All right. Anything else, Mr. Glass?
No, sir.
All right, Ms. Gittens. Anything else? Any questions, ma'am?
Okay.
All right. Thank you both very much, and we're off the record.
Thank you, Your Honor.
I'll finish writing this one up. All right, Mr. Diamond, I did write down in my docket any and all other rights and obligations created by the temporary order are hereby removed and dismissed. Okay, you might want to put that type of language in there, sir. Thank you.
Yes, Your Honor. So I believe that the order that's been forwarded on to the court's coordinator correctly reflects the ruling. I believe that the issue Mr. Brimhall is going to raise is I think I don't want to speak for him. I think there's some question about whether there was more clarity that the court offered as far as the consequences if the visitation schedule was not met. But if necessary, I'd ask the court to review the record or the court's notes, because I believe my order correctly reflects what was ruled on. I think there's an argument to be made that other things should or should not have been ruled on, but I don't believe that those are properly before the court, and I'd ask the court not to hear those issues today.
All right, Ms. San Miguel.
I am in agreement with Mr. Diamond. I think the order is properly written. I signed off on it and I don't have any issue with the order. I have issues since the order with mom not complying with the order, so I just need an order so I can force it to go after mom for $500 for every violation.
Okay. All right. Well, up to $500 anyway. So yeah, it's not as. Yes, sir. Mr. Brimhall, you're up.
Yes. I'm fine with the entire order except for the last I guess it's a sentence that I think should be added, but it's in the second to last paragraph on page 19. If the court can open up screen sharing, I can just share the passage with the court and we can take a look at it real quick. But the gist of the issue is when this court made its ruling regarding the step-ups, there were 18 total step-ups that were ordered, and the court had said that those were to be completed within a 24-week period. My original request was for the 18 to be done consecutively, which was denied, and then the court ordered that they just be completed in 24 weeks to give a little leeway to Mr. Mora in completing those. Maybe I'm wrong, maybe I'm way off base, but I believe there was some comment from the court about if those were not done within the 24 weeks, then he just had to restart the whole 24-week program again. So if Mr. Mora had done, for example, 5 visits and then took 5 months off.
I don't think, Ms. Brim, I don't think that's correct. I never said the bottom line, if he doesn't do them, somebody's got to come back in and get this updated. Okay, I can't make a what if order. So,
well, that's what I
know. And like I said, unless I see it in my notes here that I said he's got to start over, and I never make anybody start all over. I got to see what the circumstances are.
Yeah. So I guess my concern is that as the children's attorney, if he does 4 or 5 visits and then takes 4 or 5 months off.
See, again, what if? I can take a snapshot in time. If he doesn't complete the visits, then he's stuck there until somebody comes back in the court and gets a clarification. It's going to have to be on him.
Okay.
After 24 weeks, if he hasn't done them, then it's on him. All right.
So I guess just to be clear.
No, that's it.
But is he? So
no, that's it.
I just have a question though. If he's frozen, is he frozen at the first step if he only does 5 of the 8?
If he doesn't complete it, then he's got to come back in to get any further visitation, Mr. Brimhall.
Okay, all right.
That's what I write on my docket sheet. He has 24 weeks to do this. That's plenty of time. If he doesn't complete them all, and then again, I'm hearing something in the background. Mom may be doing something to make sure he doesn't complete them. But if she doesn't do it, then obviously Miss San Miguel gets the opportunity to file a motion for enforcement, and that includes fine and possible jail time. So again,
I think there was a disagreement or misunderstanding rather between the parties.
okay, well, again, I'm not gonna get into that. I'm not gonna get into that. But right now, the court's order said you got 24 weeks. If they're not done in 24 weeks, it's up to him to bring it back to the court and get a new order and get something clarified.
Okay, so if they're not done in 24 weeks, then it's just come back to court.
It's
Okay,
it's not there.
Okay.
So he's
Okay.
got so he's got 24
so he
weeks.
does. Okay, all right, I understand. So he just has 24 weeks to do them, and if he doesn't, then that's it.
Yeah.
All right, understood.
It's going to take a further order by somebody coming back in. Yes, sir. Yes, Miss San Miguel.
Yeah. And on that note, I'd like just to make sure that it's known that if it's not in the order, it's not in the order, and that
Correct.
there's no additional demand. So if she, if there's a demand to meet at the police department and that's not where the pickup place is,
I'm going
or
to
that you
object
have
to
a
her
driver's
testifying.
license,
I think Janet
then
Miguel's
she
trying to
has to come
testify
in and
about things
modify
that.
the order that it's not in there, and that's also.
I know the state doesn't like putting this in their orders, but all good lawyers put in if everything that's not dealt with or in the four quarters of this document are hereby dismissed or not part of the court order. I hadn't done one of those in 20 years. So I forgot the exact.
A Mother Hubbard clause, Your Honor.
Yeah, but the state doesn't normally put that in their orders. But the bottom line, if it's not there, it's not there. And you can't, and people can't go thinking adding things to it that are not in the court order. So yes, ma'am, Mrs. San Miguel is correct.
Thank you.
So ma'am, you got to follow the court order, and you don't get to modify it on your own, even by agreement, okay? Because this is the enforceable part. You have to comply. Anything? So 30 days from now, this will be the order of the court. This order become final, and again, Mr. Moore has that 24 weeks to get this one set up and done. Thank you. We're off the record.
Thank you, Your Honor.
Okay, so the order's just going to be submitted as is then.
I got it, and I'm signing it right now, Mr. Brimhall.
Okay, very good. All right.
Guys, does this conclude?
Oh, so wait a second, but Linda's saying I might need to do.
So, Your Honor, what I did is I sent the order that was signed by myself and Miss San Miguel directly to Miss Molina without e-filing it, because I wanted to make sure it didn't get accidentally approved. So I can ask Miss Walker to e-file. I know that's normally the process.
I'm fine with the court, based on the court's direction today. I'm fine with the OAG just e-filing what they have sent you, which is the version that I believe just has Mr. Diamond and Miss San Miguel's signature.
Correct.
So yeah, I would be fine with the court approving it based on the clarification today.
Yes, sir. Anyway, I'll go ahead and ask the state to send it over by e-file. I got, like I said, I have a copy, but I know the clerks don't like that anymore. They want everything to be done electronically, so we'll do it electronically. Thank you.
Thank you, Your Honor.
All right.
So I anticipate getting that within the next 72 hours. Well, in the next 3 business days, and I'll sign off on it. Thank you.
Okay, very good. All right. Well, that's maybe I'll be dismissed then.
Yes, sir. Like I say, you're officially dismissed off the case after 30 days after I sign it. So again, sometime in late August, you will be officially when the case becomes final, you're officially dismissed, sir. Thank you.
Thank you, Judge. Ms. Moore, you can log off and I'll give you a call to answer any questions you have.
Okay, thank you.